You rolling?
I'm rolling.
Excellent. Hi, Seth. Hi, everybody. If you're jumping into the live stream as we record this, welcome to the Toaster. We're going to be talking about equitable distribution today. And wherever you happen to be listening, you can ask a question live and it will come right in to our chat. So we can hopefully answer it as we're talking. You can always submit additional questions at howtosplitatoaster.com. And we'd love to take your questions there. And I don't know if you know this, Seth, but our questions are starting to stack up again. We've got a couple.
Oh God,
We've got.
it's great. I just always feel badly, Pete, that I feel like we don't get to them quick enough.
I know we're
So
going to
much
have to
cover.
do that again. Yeah. So anyway, very excited about today's conversation. Let's get started. Welcome to How to Split a Toaster, a divorce podcast about saving your relationships from True Story FM. Today, how do you split a toaster? Get a hammer.
Welcome to the show, everybody. I'm Seth Nelson. As always, I'm here with my good friend Pete Wright. Today, we are talking about equitable distribution, and that's just fancy legal terms, Pete. It's really just about dividing up your stuff. So let's just jump right in. We don't have to say anything clever.
You don't. Although clever is kind of our stock in trade, I understand. We shall move right into it. Tell me about Florida Statute 61.075.
You know, like, here's the thing, Pete, and this is why I said we don't need to do anything clever.
Yeah.
Is because this is all about spreadsheets, and spreadsheets are my love language.
Yes.
So
yeah, I know. I noticed you were so excited there. You nearly knocked your microphone over.
I know. I had to adjust it. Like, things are getting crazy over here. So first off, let's be clear. It is equitable distribution, not equal. So it doesn't have to be down to the penny. So what are we talking about? We're talking about dividing assets and debts of the marriage. So when we say we're going to create a schedule of equitable distribution, that is silly, fancy legal speak for an Excel spreadsheet. That's what we're doing. Now, it starts off fairly simple. You start with identification. What are we identifying? We are identifying every single asset that the husband owns in his own name and the wife owns in her own name. Every asset that they own jointly together, and every asset that the husband owns with a third party or entity, not his wife, and that the wife owns with a third party or entity, not her husband. So by way of example, I own an office building with my spouse, but technically it's owned by an LLC, a limited liability company. So the limited liability company would be identified as an asset that I own. Then the question becomes, what does that company own or do?
Right.
I own a law firm, 100% owner of NLG.
Okay.
That's going to change because we got some amazing partners and associates that are like, Seth, we want a piece of the pie. Okay. But right now, I own Seth R. Nelson, PA, 100% me.
Okay.
Okay. And that is also a professional association, and that runs a law firm. It owns the stuff and the computers and all that.
Everything in the law firm.
That's right. Okay. So when I talk about third party or entity, that's what I'm talking about. Maybe I'm on a bank account with my aunt, and technically I'm an owner of it, but really maybe I'm just helping my aunt out and paying her bills. So yes, I'm an owner, but that's not really what it is. That's where equitable comes in a minute. So we identify these types of assets first.
Okay.
Then we do the same thing on debts. Do I own debts personally? Do I own them with my, like if I have a mortgage with my spouse, that's a debt. On the car, did we both sign on the note for the car? Credit cards are usually in a primary person's name, but someone might have another card to use it. So do I have debts by myself, with a third party, with my wife? Same thing the other way. We've covered everything because you either own it by yourself, you own it with your spouse, or you own it with a third party or entity. There's no other way to own anything.
Right. So now you offer the opportunity for us to talk about why people fight about it, because it seems like it's really clear.
Yes, it's not. Because then you have to get to classification. Is the asset or debt a marital asset? If it is, it will be divided. or a non-marital asset. If it's not, it just means that it's whoever owns it. So let's take a debt, for example. Assume that when I got married, I had a law school debt. I had student loans. I obtained those
Okay.
loans prior to getting married. I became a lawyer. I'm paying off those loans. I get married and we go to get divorced. That debt was accumulated prior to marriage. It's non-marital debt. It's not part of the pie. She's not responsible for half of it.
Okay. Question. The, I know a lot of couples get married, bring debt into the family
Yep, into the
and
marriage.
into the marriage, and they then commingle finances to the point where some of the debt payment will have been provided by one spouse and some by the owner of the debt. And is that taken into account when the divorce happens and the debt, let's say a school loan, still exists?
No, it will not be taken into account at all. So, what you're describing is, let's say that my wife and I commingle our money. My
Mhm.
salary goes into a bank account, her income goes in the same bank account. From that bank account, we pay down my student loan.
Right. In
The,
addition to all the other things,
all the
mortgage,
other
cell
bills,
phone,
we're
all the
paying
bills.
bills.
Yeah. Yeah.
The court does not try to undo or reclassify every transaction that happens during a marriage. So, the money's commingled. It's marital money. That marital money was earned during the marriage and it went to pay down a non-marital debt. It is what it is. Whatever debt's left when we get divorced is still non-marital. It didn't change the
Right. It
classification.
might be less so, but it's still your
That's right.
debt.
Now, let's just use these numbers. It was 100 grand. We paid down 25, 75 is still left on my side.
Mhm.
Okay. Now we get married. It's a non-marital debt and I got 100 grand left on it and we buy a house and we pay down the house for a few years. The value of the house goes up. We want to do an addition and we're going to refinance the house to do the addition. And we say, you know what? Interest rates are low. Let's refinance the house and let's pay off the student loan because it's at a higher interest rate. And we'll fold that into this kind of second mortgage.
Sure.
Now,
Perfectly logical thing to do.
right. Except what my wife has just done in this hypothetical is she's now taken my $100,000 student loan and made it a marital debt.
Right. Because she's on the house.
She's on the house, and that debt is no longer in existence, which in a
Okay.
divorce cost her 50 G's because she's responsible for half and I'm responsible for half.
And at no point is there a recourse for her to come back and say, "Look, we did this, but technically, that's not mine." You don't
Well,
make that. I mean, if
that's
it's
what she's
truly
gonna say in the
equitable,
lawyer's office, right? But
yeah,
the court's gonna be like, "Well, no, because you've converted it. It's in your name now.
yeah,
You signed."
right,
So then there's like this whole gift presumption that is hard to get over in family court to say that that was really not like I put my wife's name on this, but I did it for estate planning purposes only when I die, not when we got divorced. So,
right,
and then I'm like, well, you better get a postnup when you're going to do that, right? You can get a postnup just like a prenup. It's just after you're married if you're going to do stuff like that. So that's where people get really upset. Or their parents, let's say that my wife's parents gave us a gift of 20 grand to help us on the down payment of a house and we're getting divorced and the parents are like, I want my money back. And I'm like, no, it was a gift. It's gone. Right.
yeah,
So like, and like these
yeah,
are now like, let's just assume we had children and now these are the grandparents of my children and now we're arguing over 20 grand or what, and I'm like,
yeah.
you're not getting
There's
it
a
back.
certain sort of
You're just gonna give it to my ex-wife who I'm very mad at right now. So no, I'm
right.
not giving you your 20 grand back.
Yeah, but I can see how there's a sort of instinctual entitlement vibe that comes with the process of splitting things up like this.
Yeah, in you're using entitlement, I don't think in a negative way. A lot of
No,
people will say it like, "Oh, they're so entitled." But this just seems like common sense fairness.
yes,
But the problem with the common sense fairness is there's no way for a judge to really determine what happened and undo all these transactions. And does it matter if this happened 5 years ago and we were married for 3, then we did the house, or we've been married for 20 and then we did it? Like, there's all
Right.
these other factors that come in. So you would think equitable distribution would be fairly simple, but it can also get even more complex when you go to classification. Because I made it pretty simple for you, Pete. You're a
Yeah.
smart guy. I said marital or non-marital. Some assets are both
How can they be
marital
both?
and
That's
I
not a
know.
thing. You're
Yeah,
making it up.
it's a thing. Here we go. And this is where the law doesn't make sense in Florida to me. When you have a retirement account, an IRA, it
Mhm.
is titled in one person's name. It's impossible to be commingled. You can't put your wife's name on your IRA. You can make her a beneficiary, but the account holder is one person. And if I start that IRA on the date that we get married and I put money into it, title to property in and of itself does not matter. I funded it during the marriage. It grew up in the stock market during the marriage. All of
It's
that is
marital.
marital to be
Yeah.
divided.
Okay.
Okay. So now I get married and I have $100,000 in my IRA and I keep putting money into that IRA during the marriage. And it now has $150,000 and we are getting divorced. The question becomes, what part is marital and what part is not? The
Is it the
$100,000.
50? The 50 is marital? Yeah.
No, nope. $100,000 that I had at the time of marriage, we all agree, non-marital. Any
Okay.
growth, here we go, Pete. Any growth on the 100 grand, the passive income, non-marital.
Non-marital.
Any money,
Contributions,
marital. Growth on contributions, marital.
marital. Oh my god.
Yeah, you got a headache now already?
That's that's terrible. I mean, I can
So,
see how this gets incredibly complicated very quickly because now we're talking about not just classifications, but classifications and dates.
and bank
And on a
statements.
20-year, 30-year marriage, that can be
That's right.
significant.
That's right. Now I'm going to add another layer of complexity. The date you file for equitable distribution purposes
Mhm.
is a big line in the sand. Okay.
How so?
Any contributions I make after the date of filing from money earned after the date of filing, non-marital. So I have non-marital before we get married. I have non-marital after the date of filing, plus passive growth or down, hopefully growth, but up or down on that as well. So
On
if
the
your case takes,
non-marital, but also on half of the value of the marital,
yeah, well, the
right?
marital, once you define the marital, you just go with the growth, let's say.
Okay.
So, but now you're defining 2 sets of non-marital,
Yeah,
before marriage and after
and
date of
after.
filing, and then everything else is marital in between, and then you gotta get all the statements, and then, let's say this is a proof problem now in court. I have to have, you know, evidence to show, and it's not beyond a reasonable doubt. It's, let's say it's preponderance of the evidence, but on appeal, do I have competent substantial evidence to hold up on appeal? Well, what happens if I only have, it's a 4-year marriage, but I only have bank statements that are every other month? So I'm missing every other month. Can
Sure.
I fill in the gaps? Is that competent substantial evidence? What happens if I'm missing half the statements? What happens if I'm missing only one statement? What does my expert do with that? Can they make a reasonable assumption? It
Okay,
gets
so
complicated.
you're giving me hypotheticals, but now I wanna know. Let's say you just have January and December of a given year. Can you not just draw a line that best fits and say, "This is look at all the appreciation"?
Well, we can look at the appreciation, but then that December statement's always the lifesaver because it says the amount of contributions for the year. Year-end
Okay.
statements are
Yeah, year-end statements.
glorious,
Yeah.
right?
Okay.
Okay, so now we have identification, then we have classification. And we've
Yes.
touched on a couple things here. I'm going to touch on 1 or 2 more before we go on to valuation. Guy gets down on one knee, Before marriage, will you marry me? Gives a diamond ring. It's called an engagement ring. She says yes. They get married. Under the law, right when she gets married, that ring is her. By the way, if they would have broken up before, the engagement ring was a kind of a contract. She would have to give it back. Side note. But yeah, I saw those. I did
Oh,
that quick. I wanted to see what you were going to say.
okay. No, that's good. You're just proving I'm listening. I get it, but I was, and that's
But
good to know. Movies
it's
sometimes are wrong.
that's right. Now, if you just give a birthday gift or a Christmas gift, never get engaged on Christmas Day. Was it a Christmas gift or was it an engagement ring?
Oh,
Something to think about.
something to
Okay.
fight about.
But now here we go. So you get the engagement ring. That was a gift before marriage. So you go
Non-marital.
get divorced, non-marital. She gets to keep it. You traded it in. You upgraded it the 10-year mark. It's now marital.
Marital.
Yep.
Okay. All
Okay.
right.
So now, valuation. Pete, some things are easy to value, right? A bank statement,
Sure.
it has the value of your bank account.
Yeah, it's literally written on the paper.
Your brokerage account, your IRA, anything with a statement. Now, some things are a little harder to value. A car.
Kelly Blue Book.
There you go.
I mean, is there an accepted standard for
Yeah.
valuation? Okay.
Kelly Blue Book is perfectly acceptable. Judge, they put in that it was in poor condition. That thing's in mint condition. So
Yeah.
Kelly Blue Book
There's a
has
range.
inputs.
Yes.
So do we argue over the inputs? Right?
Yes. Okay.
What happens when you change the zip code? Does that change the value? So you got to be
Presumably,
careful.
yes.
Right.
Yeah.
You got to watch. You got to watch those inputs. What I'd love to do is go to CarMax. They'll buy it from you. They'll give you a quote right then and there. And it's good for
Mhm.
7 days. So I've used that before. We had to have our evidence in 5 days before trial, 7 days before trial. My client went to CarMax. Here it is.
Yeah. Here's the
And
title. Tell me what it is. You now have money on paper.
that's right. So now what do we have next? A house, little harder to value. Listen, hurricanes just came through Florida. Houses are really hard to value right now. No one knows what's going on in the market
Yeah.
because a lot of houses are going to just be demolished and now lots are now abundant where before they were hard to come by. Supply, demand.
Mhm.
So what are we doing on values of houses? Real estate appraisals. You can get a real estate agent to come in and say, here's my comparative market analysis, and this is what I would list it for. This is what I think it's worth. The owner to property is allowed to testify to value. So if you own the house, you can say, I think it's worth X, and here's why, Judge. Judge doesn't have to believe you.
Sure.
And I had a case years ago, and this is the stuff you really need to talk to your lawyer about. How do we value things? Am I allowed to testify? Do we have to get an appraisal? What about this? Do you get an appraisal now for mediation, but in 6 months when you're at trial, do you have to redo it because who knows if the market's changed?
Well, I mean, you're residential, like if you're heavily invested in real estate, it sure does imply that maybe you want to hold your divorce until like February if you're in Florida.
You might, you got to, there's a
Yeah.
lot of ways when oh 08 market crashed or 06,
Yeah.
bam,
Who
like
knew?
all of a sudden.
Yeah.
So, but I went to trial and at mediation, they wanted to do a joint appraisal. And I said, no, I don't want to do an appraisal. And the mediator was like, well, why wouldn't you do that? And I said, well, we're in mediation. It's all confidential. You can't share this in the other room. I said, the other side's not on the title. And I don't think they're going to get an appraisal. And I think they're going to try to testify to value. And they're not allowed to because she's not an owner or he was not an owner. I don't remember what side I represented.
Sure.
I said, but my client's the owner. So my client is going to be the only one to testify to value. So
Tell me, you're using shorthand there. Testify to value. Is that something that just means like your client is the only one who gets to say how much this thing is worth?
You got it.
Okay.
Exactly. So now there's only one number that the judge is allowed to hear. And as long as we can back that number up with facts, and it's going to be kind of, beyond a reasonable doubt, not beyond a reasonable doubt, preponderance of the evidence, like the judge believes my client, he had a good reason for doing it, or she had a good reason, like he or she bought and traded real estate all the time. They were in the market. Like, you got to back it up. You can't just pick a number. You have to support it,
Sure.
right? So you got to be careful on who's allowed to go to court and say what they believe the value is. Okay. So
There are now, just a clarifying question. You've got CarMax as an example. There are now services that do essentially what CarMax does, but for houses, right? There are these online real estate agencies that you can just give them your house today. They'll give you today's value, and then they'll take it
right.
off your hands and do what they need to do. Is there any consideration for, I'm making no judgment by this statement, but is there a consideration for quality of sources? Like, is the judge
Yeah,
just going to say, you can't, that's not a service that we trust in this courtroom?
that's right. The judge does not have to take that as evidence or
Okay.
take it in as evidence, but give it the weight it deserves, is what they'll tell you. I'm not
Okay.
going to believe that. Great question.
Okay.
Okay, so now we have value. So there's all these ways to value things. But then how do you value a business? Is it
Right.
business just own land? Well, that's pretty easy then. We can go back to an appraisal. But what happens if I own 49% of a business? That's worth less than owning 51, and it's not just worth less than by 2%. It's cuz I don't have control.
Yeah.
So a non-controlling interest is worth less. And then it's called non-marketable interest. Who's going to buy in? If I own
At 49%.
49%, like, who's going to buy in? It makes it not, now you'll buy in at a lower price, right? But you're not going to buy in at a higher price when you can't have any control and you just got to trust the guy that I happen to be business partners with.
Yeah.
So that gets into complexities. So you got to look at these issues early on in your case because they might take experts. This is not something you're rushing to do at the end of a case.
Right. There was one of my early jobs. I worked for a firm that was, we had 15 people, small firm, training and development. It was a firm without property. It was all intellectual property. We're all consultants, right? We're
Right.
trainers, consultants. And the sole owner was evaluating, looking for a divorce, and had to value the firm, and was
Sure.
deeply disappointed at the valuation of the firm because there was, if I remember right, there's no property for the firm, right? If everybody could walk at any
Leave.
given moment, there is no value in the business. Is there in the divorce process, when you're looking at businesses, is there some sort of accounting for that?
Yes. Great question. So let's take a hairdresser. Okay.
Sure.
Hairdresser owns her own shop. She has one chair and she does a great job. Top notch clientele. Okay. Making six figures, doing hair, phenomenal at it.
Yeah.
She can't sell that business
Right.
because those people want her. They don't want me standing behind the chair. That would be a nightmare.
That would be
Yeah.
obvious.
Yeah. Short Jewish bald guy. Let's make this happen. Look, let me tell you, I give everyone the same haircut. It's phenomenal.
It's
Okay.
great. Precise is what they call it.
So now that business is generating income, right? So that's a revenue source. So
Sure.
it might be worth something to her, but what she really has, 100% of that business, other than the chair, the the towels and all the supplies, is what's called personal goodwill. And that attaches to the person. And personal goodwill is not a marital asset.
Okay.
Okay.
That's like your charm score.
That's right. So
Okay.
let's take NLG.
Yeah.
So I'm getting divorced. We need to value NLG. Now, these lawyers can get up and leave any day. And some people call for Seth Nelson, but then they don't use me as their lawyer because I tell them look, I've got good news for you. This is not a complex legal case. And I have other lawyers at the firm that can handle your case at a lower hourly rate. And then I tell them, I can't believe I'm saying this on their podcast. I tell them the other lawyers can handle it just as well as I can. And then
Oh,
I tell them I will deny that I ever said that. But now I can't deny
now
it.
you've put it in. Yeah, it's been
Right.
recorded.
So, by way of example, a case comes in and I give it to Sterling. And I tell the client, Sterling can handle this just as well as I can. He can be with Kristen Scully as second chair, and they're going to do a phenomenal job as well as I can at a lower hourly rate because this is not a complex legal case. It will be emotional, it will be difficult, it will still take a long time, but from a legal perspective, it won't be that complex. So that has value, right? That person might have called me for my personal goodwill, but now they're always going to refer to Sterling and Kristen because they did
Mhm.
such a good job. So you just got to carve that out. Um, and there's some case law that can define it very broad or very narrow, depending on the case you're looking at. So, but that is not marital. So let's say the business is worth $100,000, and the accountants say, under all the formulas we run, 40% is personal goodwill. The value is $60,000. Seth, you're going to keep your business. You're going to owe your spouse 30 grand.
Okay.
Okay.
Again, our target is equitable.
Mm-hmm.
That gets us there. Okay.
Okay. So now you go to distribution. So identification, classification, valuation, distribution. Who gets what?
Mhm.
It's kind of amazing because the way I did this, I started with valuation, but a lot of people move value, or that was third. A lot of people put distribution before valuation. And the reason they do that, they know that their wife wants to keep the house. So they're going to value it higher than if they were keeping the house. They value it lower. And I call
Mhm.
that the valuation game. So in a settlement, one spouse may overpay to keep something
Mhm.
for other reasons than just money, sentimental value, want to keep the kids in the school district, whatever the case may be. But on the fair market value, a hypothetical buyer, a hypothetical seller at an arm's length transaction, the number's the number. It doesn't matter who's getting the house. The number should still be the number. But there's a lot of swing there.
Okay. Because the way you just described it, it made me think here's a factor that might mean we're swinging away from equitable distribution if you have one party who says, I'm just going to pay you more than would normally be agreed as long as I can get this asset.
In a settlement, they can do that. In court, what happens is they go to court and they put on the house is worth $100,000 and I want to keep the house, judge. And the other side goes, Judge, I'm not arguing. She can keep the house, but I think it's worth $130,000.
Yeah.
And you think, well, it's equitable. We'll just split the difference, 115. A judge is not allowed to do that.
Okay.
Pick a number, judge. Whichever one you believe is true, you pick it. You can't say, no, I'm going to.
A judge can't make up a new number because that wasn't
That's right.
evidence, or
But
right?
what a judge can do, that's exactly right. But what a judge can do is say, I'm going to go with the $100,000 on this one. So he knows he's got a $30,000 gap. But on four other assets, I'm going with the other number in favor of the husband, making up the 30 grand.
Mhm.
He can
Okay.
do that. She can do that.
Are there other factors, just while I've got it on the brain, are there any other factors that lead the judge to, say that we're not gonna end up equitable in this case?
Yeah. So when you're, well, the judge is going to say it's equitable because that's what the judge's ruling has to be,
Yeah.
unless there's
Okay.
a petition for unequal distribution or unequitable, and you have a lot of things to prove there. But setting that aside, the judge is going to say it's equitable because that's what they're required to do.
Yeah.
But let's take who gets the dog. One of our best downloads ever. Who gets the
Yeah.
dog? In Florida family law, you can go to court and argue about the dog. And you can argue about things and say, Judge, it's sentimental to me. And here's why I want the dog, or here's why I want this, piece of artwork or whatever. We bought it on our honeymoon. I get it, Judge. It's marital, but I would like it. and it has almost no value, Judge. $100, let's call it. Okay, but it's sentimental to me, and here's why. And the judge can say, sentimental. I'm going to give it to you. You're allowed to use that for that personal property stuff.
Okay.
I'd like to make the argument that the bank account with $1 million in it is very
Sentimental.
sentimental to
Very
me.
sentimental.
It
It's
it
it's
it
my love language.
it really is a
Yeah.
million times over.
A million times
n-
over.
but I have not been successful in that in court, so I wouldn't advise it.
I have another question. Do you have more in your education, your sermon today, or may
No,
I
fire
begin the
away,
questions? All right.
fire away.
We've talked in the past about potentially a spouse hiding assets, right? And
Yeah.
can you talk a little bit about strategies for figuring out what happens when one party is hiding assets from the other, and consequences in court for that behavior?
Follow the money. A forensic accountant is great at this. You have to get all the pieces to the puzzle. So when someone's hiding money and even figuring out equitable distribution or income, there isn't one document that tells you everything. So people will say, well, if I can get their tax return, I'll know what their income is. If they're reporting it correctly, we'll take that as true. But then it's going to show interest income, which means, wait a minute, where did that interest come from? A bank account. I don't see that bank account that they've produced. So let's go get that bank. Oh, there's money over here. And now you have that bank account that you found from the tax return. And that bank account has deposits or withdrawals to a crypto account that wasn't disclosed. So you gotta kind of follow the money. On equitable distribution, ready for this? You want to get your spouse's end of the year pay stub, because it might show that they have vacation days that they're allowed to buy out. Equitable. It is a
Sure.
marital asset.
Vacation days.
Vacation days, airline miles.
Oh, would not have thought about that.
Yes.
Yeah, that
Here's
can be
another one. A
significant.
lot of people miss. If you're a member of a club and you have an initiation, let's call it 5 grand. You want to join this club, 5 grand, 20 grand, whatever it is, you pay an initiation. And usually what happens is someone's the main member and the other is the spouse. And so
Mhm.
now you get divorced. You're not under the same membership. And if my spouse was the main member and when she bought into this fancy club, it was 5 grand, but now the entrance fee is 20 grand, I'm missing out.
Yeah, right.
So maybe the judge says that's not equitable. I'm going to give Mr. Nelson 10 grand extra on this side, right?
Okay.
Go apply
All
to
right.
them. So, and a lot of people miss that. And then they get divorced. It's over. They go to the club
And
and
they're not
all
a
of a
member
sudden
anymore.
you're not a member anymore. Well, can I
Yeah,
join? Sure. Give me 20 G's. What about
yeah,
my 5?
yeah. Okay. That was, I wanna, point back to consequences for hiding assets in court.
Yeah. So they're not the way they should be. My view is if you are hiding it and we find it, it should just be ours. Like that's kind of my view on
Is
it.
the Florida statute finders keepers? Is that what we're
Yes,
doing? Yeah,
yes, that's the one I'm looking for.
yeah,
But what happens is you found it, so you're gonna get half of it. But
yeah.
there's not a lot of penalty for that. Now, if it's extreme, if they're not producing documents, it gets crazy. But they'll just say, "Oh, no, judge, I didn't realize I had that." Like they make excuses. And that's why you just gotta follow the money on these documents. And you gotta dig into them. You can't just breeze through them, and that's why it takes some time.
Prenuptial agreements. What impact does the prenup have on equitable distribution?
If the agreement is valid and enforceable and it says what's going to happen, then that's what happens. And usually what it says, whoever's the owner of the property in name, in title, keeps it. And so then you don't have all these valuation issues. You don't have you still have identification. You want to make sure you get everything, but most of it's going to be non-marital according to the prenup. Now, if it in the prenup says, but if it's in a joint account, then we'll divide that. And
And
then
and anything acquired through the marriage is something you now have to distribute equitably.
no, whoever paid for it keeps it.
Okay. We
So,
got a car together.
well, did you make it joint name? If it's
If it's
joint name,
sell it, take the value.
yes. Or if it's joint name, it's equitable distribution
Okay.
to be divided. But if I go buy a car in my own name, it's mine.
It's your
If I
car.
go buy a car with my wife and we're filling out the paperwork and I said, "Honey, I'll handle the paperwork. This car's for you. You're going to be driving it. They're going to take you through and teach you how all the buttons work."
Mm-hmm.
And when we're filling it out, I put my name on it. In the
That's
divorce,
yours.
it's mine.
Yeah.
It's titled in my name.
That is a
Depending,
lesson that's hard learned, I think, and there are a number of circumstances we've talked about it before because in dealing with death of a parent,
yes.
when when the car owner died,
Yeah.
like, that ends up being complicated,
Yes.
and so that is a really interesting one because that happens all the time.
Yep. Yep. And sometimes I did it very deceivious, like I'm trying to pull one
Yeah,
over on her, right?
yeah.
But I would thank you. That's
I noticed you started to whisper as if she
yes,
was
yes.
listening.
Well, which was really silly because she never
She
listens to
doesn't
the
listen.
show. I could scream it from the rooftops.
Yeah,
So,
right.
but at the end of the day, it might just be, oh, I'll handle the paperwork. Go look at your fun new car, and it, oh yeah, it's in my name. You don't even think about it, right? Like, but the other thing is, who really keeps receipts on who bought what during the
Yeah,
marriage?
yeah,
I mean,
nobody.
so there's all sorts of things that I put in prenups to try to make, and really what I work really, really hard in prenups is to not have litigation. That's the whole goal of the
Yeah,
prenup.
right,
So
right.
I have a lot of language on how we divide things, who gets first choice, who gets second choice, how do we value things? Do we pick a data value so we're not arguing over a data value because it can go from the data filing all the way to trial date? Like there's a lot of things to argue about, and that's what I try to do in prenups is really not argue, not have litigation.
Okay, okay. Anything changing in Florida law that or has recently changed that changes the way people think about equitable
Not
distribution?
really
Do
on
we need a
equitable
legal update?
distribution. No, not like in alimony, where there's the
Yeah,
big change, not like in the parenting plan, with the presumption of 50-50. But it really is basically the same, but there's just a lot of nuance to it. And a
yeah.
lot of lawyers will say, it's all math. I went to law school because I couldn't do math. That's why I'm not a doctor. And I'm like, 4 out of the 5 issues we deal with in family
Or
law are
math.
money,
Yeah,
and it is nuanced and complicated. And um you can really save your clients a lot of money, and you can lose them a lot of money if you don't know what you're doing and you're
sure.
not really keeping your eye on the ball. So
Well, we actually have a question that I believe deals with commingled funds. Shall we turn to a listener question?
let's do it.
This comes from Commingled in Cali. Commingled funds in divorce. Bear with me. This one's a little bit of a story.
Okay.
I inherited 2 large sums of money from my family, both before I ever got married. The money was in another European country, and I moved the money to the US during my marriage. I am in California. The first sum was I think this is a word problem, and there might be trains leaving from opposite coasts shortly. So here we go. The first sum was invested in a brokerage account in the US under my name, but I moved it into a shared brokerage account that already had a small balance. Since then, no contributions have been made. My portion is about 75% of the money. The other 25% are marital funds. The account has increased significantly in value. One, I've been told if I can trace the money, I can recover my share plus half of the marital funds. Is this correct? Two, if yes, what do I need as proof to show my portion of the money is mine? The second sum was used as down payment for our home. I've been told I can only recover the actual amount originally used as down payment, which hurts because the value of the house has more than doubled. I get that we have been contributing to it and made improvements with marital funds, but the original down payment was almost 50% of the purchase price. What's your opinion about recovering more than the actual original down payment plus half of the remaining value? Is it reasonable to fight for more? Is it possible to get at least a portion of the value increase since we could have never purchased the house without my money? So, two parts to that question. Take them in whatever order you would like.
Let's start with the house because we mentioned that before. Just in
Right.
my examples, you put down
Yeah.
a down payment. You made non-marital money marital. I don't know California law. It was a California question. So yeah, check with your local, attorney and you check your local jurisdiction, the laws and the case law and the statutes. But in
If
Florida,
you're in Florida,
that money
it's
is
gone.
now marital. Now,
Yeah.
here's the good news about that. Okay. In fact, she said, or this questioner, the questioner says, I'm at least going to get my down payment back. In Florida, that might not happen. Like you don't get it back at all, except always remember you get half of it back
Because
because
that's
it's
now the
part of,
value of the home.
you got it.
Yeah.
You got it, Pete. Okay. So that's the house one. The brokerage account is interesting. Check your local jurisdiction. It's a little bit analogous to the IRA in the sense of you're putting money in, you can identify what stocks and what bonds were purchased. Those are items. If you think about it, you buy a stock, you can sell a stock. You can see exactly which stock it was. It's not like cash that's fungible. If it's a cash account, like a bank account, a checking account, and you put the cash in, you can't tell $1 from the other.
Right.
And it's all commingled. So on brokerage accounts, check your local jurisdiction. Maybe you can say, look, I bought a specific item and therefore it's equitable. I can trace it back to that item. Cash accounts, you can't do that. Retirement accounts, you can.
Okay.
Great questions.
Interesting question, and timely that it feels like a bar question a little bit. That you just talked about it.
And this is what people don't really understand about the law. No client comes in and says, I have an equitable distribution question and I need to know the difference between marital and non-marital and valuation. Like they might Google some stuff now, but they come to us with these fact patterns. And it's the lawyer's job to say, oh, we're talking about equitable distribution. Here's the law in Florida. Here's what we're dealing with. Then, as you can see, facts matter. Information matters. How much was put in? Can I make an equity argument here?
Yeah,
right?
Right.
And here's the problem when you're arguing equity. The facts aren't on your side. And the facts might be, but the law's not on your side. When you take the facts that we all agree on and apply it to the law, it doesn't help you. It hurts you. And then you say, but judge, it's not fair. When you're arguing equity, you're already losing. Right? And the judge might say, yeah, I hear you, but I mean, the law says this, and this is a court of law and equity. And, judges don't want to get overturned. They don't, one, they don't want to be wrong. They don't want to be told they're wrong if they are. And to the judge's credit, they don't want to have more litigation in an appeal and then gets remanded and it hurts the parties. I mean, they're not just saying for their own ego. It's they want to get it right the first time. So
interesting stuff, man. There's always more to this. It seemed like you were setting me up for a really easy one today, and you absolutely did not.
Well, Pete, if they're easy, people aren't learning.
That's right.
They know the easy stuff.
I know the easy stuff. So I will say this. As for easy stuff, I can say thank you to Commingled and Callie for writing in such a thorough question, giving Seth all the right facts and information to be able to give you at least something, just something to hang on to and maybe new questions to ask in your local jurisdiction. Thank you for doing that. And everybody, you can ask us all the questions you want. Just head over to howtosplitatoaster.com. Press that button that says, hey, submit a question, and that'll come right to us. We will ask Seth that question on a future show and see how he handles it. I think he's going to do okay. I feel good about it.
Thanks.
Thank you, everybody, for downloading and listening to the show. We sure appreciate your time and your attention. On behalf of Seth Nelson, America's favorite divorce attorney, I'm Pete Wright, and we'll be back here next week on How to Split a Toaster, a divorce podcast about saving your relationships.